Welcome to Benson on Injury Law.
Hello and welcome back to Benson on Injury Law with attorney Paul Benson. Paul is a personal injury attorney based in Wisconsin, and he spent the last decade helping people across the state get the compensation that they deserve after serious injuries. Paul is committed to guiding clients through the confusion that follows a serious accident. My name is Kevin Rosenquist, and today we're talking about slip and fall cases and what Wisconsin law really says about what a property owner is responsible for. Hey, Paul, how's it going?
Hey, good. Good to see you, Kevin.
Yeah, good to see you too, Paul. What do you look at first when you evaluate whether a slip and fall or a trip accident could be a legal claim?
Sure. These are really hard cases. The first thing you're looking at is the cause of the fall and whether I think I could prove to a jury of 12 regular people that this was an unreasonably dangerous condition. So does it pass that first glimpse test? Because I think in these cases, I think juries make up their minds almost instantly by looking at the feature. So I want to look at the photos and say, do I think that I can prove that this is going to be unreasonably dangerous, or am I going to get laughed out of the courtroom? The next thing you have to look at in Wisconsin is whether that condition was caused by a potential design or construction defect. The reason why is we have something called the statute of repose, REPOSE, and that means that businesses are not responsible for construction or design defects if they are more than 7 years old. So then they're grandfathered in and you can just have this dangerous condition in your property. I think it's a really bad law that incentivizes keeping dangerous conditions, but that's the law. So you need to make sure that if it is a design defect or a construction defect, that you have some other theory of liability to get around that. Like, for example, they failed to maintain the property properly, which caused that condition to arise, or maybe they failed to provide adequate warning. But that's the next thing you're looking for, is just how old the construction is and whether that defect was caused, that dangerous condition was caused by a construction defect or a design defect.
So then how do you prove this? And what does Wisconsin law say you have to prove? You listed a few different things, but
yeah,
how does that come together?
So the first thing is that there are different standards for homeowners and business owners.
Okay.
So you have to prove different things. Against homeowners are only held to the standard of ordinary care. It's frankly a pretty low bar. So you don't see many of these cases against homeowners because it's a pretty low bar. If we're talking about trip and falls and slip and falls and things like that, I can get into some other claims later. Business owners, we have something called the Safe Place statute. And that statute says business owners, if you are taking money from the public, if people are coming on or invited onto your property to make money, we're going to hold you to a higher standard, and you have to keep this property as safe as reasonably possible. So it's a much higher standard and puts duties on them, like to inspect the property for dangerous conditions and things like that. Once we've decided which bucket we're in, homeowner or business, then we go about proving negligence and whether or not they fell below that standard of care, either ordinary care or did they do everything reasonably possible to keep the property safe. That's what we have to prove.
What about things like, you're in Wisconsin, ice and snow and things like that. Is there a different standard between a business and a person, a residence when it comes to that?
Yep, same thing. So there's that ordinary care that applies to homeowners. So if it snows in the morning and someone slips on your walk in the middle of the day, you're probably not going to be liable for that, the homeowner, because they haven't had a reasonable enough time, to clear that off. If that happened at a restaurant or a gas station or a store, completely different situation. If they've had enough time to get someone out there to clear that, then they're going to be held responsible. So they're very different standards in Wisconsin as far as business owners and homeowners. And what I see is defense lawyers and insurance companies, what their goal in all of these cases is to try to make that homeowner feel like they're going to be next, like they're going to be sued and held to the same standard that we're holding a commercial business too. And it's just not the case.
Yeah, I've always wondered about that because I've worked in places, before where I might have been the first person there, and I would shovel. I'd shovel everything, but I didn't get there till like 8 o'clock. So if someone slipped at 7 in the morning, would the business in that scenario in Wisconsin be held liable? Is that reasonable? I mean, or do they take each situation into its own account?
That would be a tough call. It would depend on what kind of business they are. And
Hmm.
did that business have a reasonable expectation that someone would be there before business hours? So the
Okay.
word reasonable does a lot of work in a lot of these cases.
Yep.
So it's all about that reasonableness standard and whether it be reasonable for them to expect someone to be there. If they knew that the UPS driver came before business hours every single day, well then yeah, they're probably going to be held responsible for something like that. If it was a one-off person who's trespassing and this business wasn't even, let's say, customer facing, then no, I do not believe that a jury would be likely to hold them responsible in that situation.
Okay. I'd imagine, I mean, photos, video, maintenance records, these must be crucial to you when you're trying a case.
Yeah, I mean, photos are everything, especially in like ice cases because the ice is changing all of the time.
Right.
And one person's recollection can be totally different from a different person's recollection. But any kind of condition, taking a photo, a lot of photos, frankly, is very important to proving the case because things change over time, sometimes very, very quickly. I had a trip and fall at a gas station where that gas station happened to get repaved the very next day and the camera wasn't working. So I was stuck with no evidence of what that pothole allegedly looked like. I ended up not taking that case or not pursuing that case after we found out that there was no video available because we didn't have the evidence and the plaintiff
Mhm.
has the burden of proof. So without that evidence, I'm not going to be able to meet that burden of proof. So yeah, taking a photo as close in time as possible to the injury is super important. I realize, especially in the case of a serious injury, you're probably not going to do that right after you fell. But if you can think about it in the next 24, 48, 72 hours to go get photos, that's going to be hugely important. The other thing is just reporting it to that business or if it's a homeowner, but especially in the case of a business for a few reasons. Number one, they can document it with an incident report, and you always get good evidence out of that incident report. Number two, they're going to be on notice now, and Wisconsin law is going to require them to do everything they can to preserve any evidence, including surveillance footage.
Mm.
So if let's say we didn't get a photo, at least if you put them on notice reasonably quickly, like in the next day or two, they're probably still going to have surveillance footage, and we're going to be able to use that to look at to hopefully be able to prove your case.
Okay. Yeah, I was going to ask you about that. And is there any situation where you shouldn't go in and talk to the business owner, or pretty much every time you should do it?
I think every time you should go report it. Again, unless you are so injured
Yeah.
that is not reasonably necessary, you can always give them a phone call later. That'll work just as well. Even better is to try to follow up in writing and prove that you did that. So if this business has an email address or whatever it is, that would be a great way to do it. Or do it the old fashioned way and even send them a letter. If it's a business that doesn't have an email or something like that, do something to document that you reported that injury. Because if there's no documentation, one defense they will undoubtedly try is to say, are you sure this even happened? Are you sure this even happened here? There's no proof that it did. How do we know you didn't fall at your own house and you're basically trying to
Mhm.
collect against an insurance policy? So whenever possible, try to document that injury.
We live in a world where people are very distracted, especially by the computers in
Yeah.
their pockets. Like, how does that work? If someone tries to make a claim and you can look at the video, it seems like they were distracted, looking at their phone, not paying attention to what they were doing. Does that change the course of the case?
Absolutely. I mean, it can completely ruin your chances of getting a recovery if you were whatever streaming something on your phone or whatever you were doing. It's going to make recovery very difficult. An interesting, just human psychology thing is, as now people are becoming more addicted to their phones, are are we going to hold businesses basically to the standard that they should know that people are always looking at their phones, so they need to keep the place even more safe? That's going to be an interesting thing that evolves in the law now, because we do know that so many people are so addicted to their phones that businesses might have to start taking account for that. But as of right now, I don't think that's the case. I think that if there's evidence that someone's looking at their phone and trip over something, that's probably going to be on them.
Yeah, and I think like you probably end up being that word reasonable, right? That'll just keep
Yep,
changing wherever that line is. It'll just keep changing.
it does. It's always changing. It's exactly correct. It used to be people would make a big deal if you were wearing like flip flops or something in a store. Like, well, that was a bad decision. Now they're ubiquitous. They're everywhere, so you don't see that defense as much anymore.
That's a good analogy, actually. You're right. Yeah, I mean that used to be a thing you only saw sometimes, maybe only in like beachy places. But yeah, you're right. Everywhere you go now, it doesn't matter. Here in Colorado, I'm in Colorado. It can be like 50 degrees and people are walking around in shorts and flip flops in the stores. So,
Yep.
do you often see long term injuries coming from these types of cases, or are these a little bit less than a car accident would be?
I do. You see all kinds of injuries, especially on these ice cases.
Mm-hmm.
Sometimes people slip and fall, and the fall can be worse than any car accident because people are just completely unprotected when they fall. They're not expecting it. They don't have time to brace for it. So you see really, really bad injuries, especially in my opinion on these ice cases is where you see some really, really traumatic brain injuries, fractures, hip replacements, that kind of thing because of a slip and fall.
I went to college in the Midwest. I remember walking around and I definitely bit it. I definitely fell before. Luckily I was okay, but it does not feel good. It definitely does not.
Yeah, I mean, there can be absolute long-term consequences from some of these injuries, and that's where it's important to get a lawyer involved, because you just don't early on, because you don't necessarily know right when you fall that this is going to end up being a long-term injury.
We've talked in the past about the tactics that insurance companies will use when people get in car accidents and how they try to lowball them and all that stuff. Are similar tactics used in these types of cases? Are there other things that they do to try to minimize damages on their end?
These are normally different. They're normally not involved as quickly as the auto cases. Just the nature of an incident report getting filled out at a grocery store or a hotel that normally doesn't get to the insurance company as quickly. So I would say it's different. Um, One really important thing is they're going to want to get a statement from you on the phone, and they're going to ask you really specific questions about which foot did this and where were you looking when this happened. And they're going to try to lock you in to a bunch of things that later you're going to get cross-examined on, and you are going to testify differently a second time, because that's just human nature. You're never going to tell the same story exactly the same. So that's the number one tactic that I see, is they're going to try to get that recorded statement with crazy specific questions about where this foot was, which foot slipped first, which body part hit the ground first, that kind of thing. Try to lock you in.
Jeez, who remembers that, right?
Well, exactly. And a lot of people don't even remember they gave this recorded statement. Then, I'm defending them in a deposition, and they're going to get cross-examined. What happens? They're going to get cross-examined and say, well, you said this back then, so not giving that recorded statement is really, really important. The other tactic is they're just going to deny your claim and frustrate you. They're just going to deny and delay. You see that more on the slip and fall side than the auto side. So they're just going to deny your claim, say we weren't liable, and just delay to try to get you frustrated so that you give up. So those are the things I see more on this premises liability. Think about the slip and fall injuries that happened at, just businesses, hotels, restaurants, grocery stores, things like that. It's a different playbook from the insurance company for sure.
What kind of mistakes do you see people make that you'd love to maybe try to help them not make if anything ever happens down the road, that particularly in these slip or trip and falls?
Failing to document it with photos is number one.
Yeah.
So if that, like we talked about before, getting the photo of what happened and then making that report to the business, those are the two things that you can't go back and do after the fact. And then, don't give a detailed recorded statement that's going to later be used against you, because again, their point in that is not just to assess their risk. Their goal in that is to have that as a a tool to use against you in litigation, that they know you're never going to be able to testify 100% consistent with that first recorded statement, whatever, 2 years later, and they're going to try to use those inconsistencies to make you look like you're lying. So I would say those are the main things: is avoiding that recorded statement with the insurance company until you have counsel, and then not taking those photos of the dangerous feature, especially in cases like I'm thinking right now, like liquid cases in grocery stores or things like that. A jury is going to maybe hold a grocery store responsible if there's a giant spill that had been there for clearly a long period of time that the store should have been able to discover. A jury's probably not going to hold a grocery store responsible for a few drops of water on the floor. So if you don't want it to be your word against theirs, take some photos so that we can prove your case.
Outside of needing an ambulance, is there ever a situation where you would recommend somebody call 911, call the police in these situations?
I don't think so. No. You see people do it because they want the documentation.
Sure. Yeah. It seems like the right thing to do, I think, in a lot of people's minds.
I think so. What I've seen though is it's not, because there's nothing criminal. It's not required by like a car accident. If there's more than $1,000 of property damage, you have to call the police. That's the law in Wisconsin. In this situation, the police probably aren't going to come. If they do come, they're going to be annoyed and write a report that doesn't favor you. And then the defense is going to be able to paint you like some lawsuit happy person that's just trying to make a buck. Like, why would you call the police because you slipped at a grocery store or a hotel or something? Like, why would you get the police involved? I think that they tried to make you look bad for that. So a better option is to document yourself with photos and then make that incident report to the ownership or management.
At what point should someone call someone like you?
Right away. Again, if the injury is serious enough that you go get checked out by, an urgent care or something, that's probably serious enough to get me involved, because you don't know the full extent of your injuries. That injury might end up being a lot worse. I've had cases like that where early on doesn't seem that bad, ends up being very bad in a complicated case.
Mm-hmm. All right. Well, great advice as always. And thank you for listening to Benson on Injury Law. To learn more about how Paul Benson helps Wisconsin families after serious accidents, visit paulbensonlawfirm.com. Don't forget to subscribe, leave us a review. We very much appreciate you checking out our videos. Paul, always great chatting with you. Thanks so much.
Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.